Terry? I hope I'm audible.
Yes, you're audible.
All right, let us bow down for prayer. Our Father in heaven, we come to you this evening. We want to thank you for this privilege to be able to meet. Thank you for each one of us who has been able to log in. We ask that you be with us in learning how to prepare our will so that it can be useful to our lives, and also so that we can pass it on to others. Be with us, Father, for those who have not arrived, if there are any still on the way, would you hasten their pace, Lord, so that they join us to benefit from this learning. In Jesus' name I pray. Amen.
Thank you all for coming. This evening, we are going to learn something which is very important in our lives. And I'd like to welcome the presenter, that is Advocate Baroness. She'll take us through the will writing and execution topic. Francis, who was in the poster, was called for an urgent meeting, and therefore he was not able to be with us. And that is why we have Baroness. So you may see there's a different person presenting, but she is qualified. She is an advocate of the High Court, and therefore she'll take us through, and let's be open to ask questions so that we can be able to write these wills the correct way, and that they'll be impactful in the way that we intend them to be. So I'd like to welcome Baroness Okweto so that you begin your presentation. Welcome. Baroness, you are muted. Please unmute.
Yes, I was saying thank you so much for having me this evening. Please confirm that you can hear me well.
Yes, we can hear you.
Thank you. So I think you've already introduced me. I'm an advocate. I practice in Nairobi.
Justin, please mute.
Yeah, I was saying that I practice in Nairobi. I do litigation. That means going to court for court matters. I also handle commercial cases, criminal cases, generally litigation. I do a lot of conveyancing also, and family law. So I'm really grateful for this opportunity. I think we'll go right into it. Let me just share my screen so that we're able to see the presentation. I don't know if you can see my screen now.
Yeah.
Yes.
Yes, just a minute as I get to the presentation itself. Yes, I think now we are good to go. Yes, other than practicing, I also sit in the Child Law Practitioners Committee, where we deal with issues to do with laws affecting the children. You know, there are very many cases concerning children, so I also sit in that committee where we advise the society as how to proceed with matters in relation to children who are also in conflict with the law. So as a starter, I think it would be important for us maybe to know what expectations we have this evening. Dr. perhaps you could pick 2 people or 3 so that I know what they expect to learn today at the end of this training before we start.
Okay. Let's have Lillian Karongo. What are you expecting from this meeting, Lillian?
Hi, good evening.
Good evening.
I think I'm looking forward to hearing more about how we can demystify the myth that a will is only written by the people who are about to die, but also the guidance on how to put it down in a fair way, to write it in a fair way, and where we should keep it when we write it down, and probably the scope.
Okay, thank you. Thank you, Lillian. One more person, perhaps the last one, then we proceed.
Okay, the last one, Justin Kimani, what are you expecting?
Thank you, Doc, for that offer. I want to know whether the will I have already written conforms. Is it well done? And if it's not well done, where would I refine it to make it conform?
Okay. I think that is good. Thank you so much for just sharing your expectations. Is someone trying to speak? Hello?
No, you can go ahead. Go ahead.
Okay, thank you, thank you. So generally, when it comes to wills and anything to do with succession in Kenya, they are governed by the Law of Succession Act, which came into force in the year of 1981 and has been enforced since then. So basically, the act gives directions on how succession should be undertaken, be it in an instance where someone dies without a will or they die with having written a will. So it provides for matters relating to succession, the protection and administration of property of a deceased person. So which means basically that the law also gives guidelines, can give guidelines on how property should be divided when it comes to people who are surviving a deceased person. So succession to rights can be intestate or on the basis of a will. When we say intestate, we basically mean that someone has died having not written a will. So in this case, the law will kick in and someone would have to apply for the court to issue them with something called letters of administration for them to administer the estate of the accused. And on the other hand, if someone dies having written a will, then normally the executors would present that will to court, apply for something called a grant of probate, so that they can administer the estate of the deceased person according to the wishes as they had written in the will. So there are a few words which we are going to go through, or rather we are going to meet in a presentation this evening. And first and foremost is the word will. So what is a will? It is a declaration by a person of his wishes or intentions regarding the disposition of his property after his death. I think that is clear. And let me just mention that a declaration may either be made orally or in writing. So there is no, rather there is no restriction on how it can be, but there are those two options. As long as someone says that this is my will, this is how I want my property to be disposed in the event that I die. Then the second one that you're going to meet in our presentation this evening is the word codicil, which is an instrument made in relation to a will, either explaining, altering, or adding to any part that had been written initially in a will. We'll find that someone writes a will, so in the event that you'd like to make any additions or alterations to contents of that will, what you prepare is a codicil, which then is executed as though you are making the will, but it's just an addition or a change to the will that had been made prior. And then thirdly, we are going to meet the word testator. This is basically the person making the will. The writer of the will or the maker of the will is referred to as a testator. So Justin, at that time when you were making that will, you were a testator. And then the last word that I've put down for definition is the word executor, which refers to a person to whom the execution of the last will of a deceased person is, by the testator's appointment, confided. So an executor is basically someone whom the testator chooses and says, when I die, this person will be in charge of administering my estate and doing as I desire with accordance to my will. In case you lose me, please do mention so that I know that we are together. So there are types of wills which emanate from how they are made. And the first type would be an oral will, and the second type would be a will that is written. So I want us to look at what makes a will valid. What makes a will valid? So once you've written a will, or rather as you're considering to write a will, there are some things that you need to take into consideration so that you do not come up with a document for someone to challenge later on and say that will was not valid for reason 1, 2, or 3. So there are some things that you must consider for a will to be valid. And when I say valid, I mean valid in terms of it being legally binding, or for it to take effect, say for example, in a court of law, or in whichever case, for example, someone has died and you have to take it to court, then these will be the things that the court is going to be looking at for them to say that indeed this is a valid will or it is not a valid will. So a will that is valid or considered legal, for example, is based on 2 things. Number 1 is capacity, and number 2 is the form. So when you talk about capacity, there are very many things that you could consider, but of importance is number 1, age. First, let me mention that there is no limitation when it comes to age. If someone wants to write a will, they can write a will. You don't have to be 50 to write a will. You don't have to be 70 to write a will. Even minors can write wills, but there is a caution to that. So when it comes to age, a will must be written by someone who has attained the age of majority. And just as I mentioned a few minutes ago, a minor can also write a will, but then they will have to execute the will once they reach the age, they attain the age of majority. Remember, I mentioned that executing would mean just signing. So in the event that a minor writes a will and they sign the will, once they get to 18 years, they would have to sign it again. And or if they will not sign it again, then they make another will to revoke the first will that they had made before. So in the event that a minor makes a will and he dies before attaining the age of majority, then automatically the rules of intestacy are going to kick in. This means that if he had an estate, if he had property, if he had shares, for example, in a company, if he had a bank account that had money, then once he dies before attaining the age of majority, even if he had written that will, then the court would consider that that will was invalid, and so the rules of intestacy are going to kick in. And when we say the rules of intestacy are going to kick in, it means that the court is going to appoint someone to come in so that they can administer the estate. Then secondly, we look at mental or testamentary capacity. I like to mention that this is very important so that when you're signing a document, when you're preparing a document, you must have the mental capacity to understand what you're doing at that point in time. So this is one of the most key parts, for you to consider when you're making a will. So number 1, a person of unsound mind cannot make a valid will. And I think that is clear, so that they're not able to discern exactly what they're doing. They're not able to understand, maybe they're passing off property to someone. So if someone has unsound mind, then the court would definitely say that they're in no capacity to write a valid will. But then the question would arise, how about the people who normally have lucid moments and at times they're insane? So the law is clear that in the event that a person of unsound mind makes a will, at the time when he or she is at their lucid moment, then that will be regarded as a valid will before the eyes of the law. Then thirdly, I want us to look at knowledge and approval, which is still under capacity. So the maker of the will must know and approve the contents of their will. And I think this is just basically to know if you have property located somewhere, if you have shares, for example, if you have a car that you want to dispose of, you as a testator must know and approve that you're giving out your property to a certain beneficiary. Then the maker of the will approves the terms of the will if he executes it in those terms on his own volition. So this basically means that you've drawn a will and you're happy with how it is. For you to sign, it means that you have knowledge of what you're willing to other people and you're actually approving the contents of that will, that they're a true reflection of what you desire as a testator. I don't know if we are together or have I lost people?
Okay, it's okay, it's okay.
I'm still
Okay.
there.
Thank you, thank you. Secondly, we are going to look at the form. And here, I did mention that there are two types of wills, the ones that are made orally and the ones that are made in writing. So under the form, this basically means the format. Number one, you're going to look at an oral will. So this one must be made in the presence of two or more competent and independent witnesses. So let's decipher first the first part. In the presence of two or more competent, when you talk about competence, look at it from the perspective of the person witnessing having a sound mind and knowing why they are signing as a witness in that will. And then when you talk about an independent witness, it means that this is a witness who is not a beneficiary under that will. So for example, for the will that Justin has written, I come in and I sign, I would be a valid witness. I'd be regarded as an independent witness because I'm not a beneficiary under that will. But say, for example, Justin writes that will, and let me just, off the top of my head, he has a son, for example. That son, he has given, say, for example, property located in Rongai to that son. But then he also wants the son to come
We have lost you, Council. Council, we have lost you. Hello, we have lost you.
Baroness, we've lost you.
It's still picking up, maybe. Maybe somebody has called his her phone.
witness.
She sounds like she's still presenting.
Yeah.
Baroness? Baroness, we lost you.
It would be regarded, he would be
Baroness?
regarded as, in case, let me just
We lost you a long time.
mention.
We have lost you for almost 1 minute.
I don't know if you can hear me now, audible now.
Now we can hear
Okay,
you.
but you,
Yeah, you
Yes.
can repeat the oral parts. Yes.
I apologize. Yes, so as I was saying, an oral will has to be made in the presence of two or more competent and independent witnesses. I wanted us first to understand who a competent witness is. And I said that a competent witness, when it comes to competency, this would speak directly to the state of their mind in terms of their sanity and whether they understand why they are signing as witnesses in that will. And then secondly, I want us to understand who an independent witness is. And I was given an example of Justin and the will that he has written. Say, for example, I come in and Justin wants me to sign as a witness. I would be considered as an independent witness because I'm not a beneficiary under his will. But also on the other side, if Justin has a son who he has gifted, for example, his land located in Rongai, and he also wants the son to witness the will, then the son would be considered as a witness who is not independent because he has a stake as under the will. Before we move on, I'd like to mention that in the second case, where someone is a beneficiary but also a witness under the will, the law requires that his signature be witnessed by 2 or more competent and independent witnesses. So other than him signing as a witness in that will, his signature itself will have to be witnessed by 2 or more witnesses. I don't know if we're together up to that point.
Yes.
Yeah.
Yes. So the law provides that an oral will can only be valid 3 months, within 3 months after making of the will. And if 3 months, if it can only be valid if the testator or the maker of the will dies within 3 months after making the will. In the event that they do not die within a period of 3 months after making the will, then that will automatically will not be considered as a valid will. This normally happens so that, say for example, someone makes an oral will in a rush and they've not thought through, they've not understood what they're doing. The 3 months basically will help them to think on what they're going to do. And if they lapse before they die, then they would have time to maybe even reduce the whatever they had in mind into writing. I will also mention that normally oral wills will work for people who are, say for example, in the armed forces, people in the Navy, because the conditions in which they work in and the environments, someone might go to war and you're not sure if they will come back. So in the event that someone makes an oral will while they are in battlefield, for example, or while they're out there fighting, then that would be considered a valid will. And the provisions and the proviso that that an oral will is going to automatically become invalid in case the person does not die within 3 months, then does not apply to this class of people due to the nature of their work. So as I had mentioned earlier, we are talking about the form. We've talked about oral wills. Secondly, I want us to look at wills that are in writing. So these ones may be handwritten or typed, then printed out. So you could just use a piece of paper, write down your wishes, how you want your property to be distributed in case you die, for example. And you could also have it typed, and then it is printed out for you and your witnesses to sign. And there are requirements for a written will for it to be considered valid. Number one, a written will must be signed by the testator. And in the event that they cannot sign, then they can affix a mark. They can put their thumbprint, their initials, or any assumed mark that denotes who they are. Then this should be done in the presence of 2 or more competent and independent witnesses. I've already explained who competent and independent witnesses are. And just something that we need to understand, a question normally arises where someone asks, so in the event that a testator signs and both witnesses are not present at that time, what happens? So the law provides that the witnesses do not necessarily need to sign the will in the presence of each other, which means that a testator can have the will and he or she has to sign in the presence of both witnesses. That is number one. A testator has to sign the will in the presence of both their witnesses. And when it comes now to the witnesses, it could be the testator and one of the witnesses. So there's no requirement that both witnesses must be present together, signing at the same time. But what the law provides for is that the signatures of the witnesses must be signed in the presence of the testator. I don't know if we are together up to that point.
Yes.
The signatures of the witnesses.
Sorry?
You said the signatures of the witnesses should do what?
I'm saying that for when it comes to the witnesses at the time when they're witnessing, they do not have to, the two of them do not have to be present at the same time. But the law provides that whenever they are signing, then the signing must be done in the presence of the testator. I don't know
Okay.
if that is clear now. Yes, yes.
Yeah, it is for me.
Yes, thank you. And then we proceed. So the witnesses should be uninterested, meaning that they're not beneficiaries of the will. I already explained that above. And in the event that a witness is also a beneficiary, then their signatures ought to be attested by at least two additional competent and independent witnesses. I also explained that using the example of Justin, and that if I come in to sign as a witness, I do not have any stake in the will, so I would be considered as a competent and independent witness. But if Justin makes a provision for his son or his child in the will, and also wants his child to witness the will, then his child's signature will have to be attested or rather witnessed by two or more other competent and independent witnesses. And the law also provides that if the signature of a witness who is also a beneficiary is not attested by other witnesses, then the bequest to such a witness or beneficiary is considered void. So I'll go again to the example of Justin's son. He is a beneficiary under the will. He is also a witness in the will. So in the event that his signature is not witnessed by two or more competent and independent witnesses, then any property or any property that has been given to him by his father within the will is going to be considered void. I want us to look at the myths and misconceptions about writing of wills. Being Africans, you know, we are traditional people, and there's a way we look at some of these things. So I was able to come up with a few. Sorry, someone trying to speak?
Proceed.
No.
Proceed. No.
Okay, yes. So I've come up with a few myths and misconceptions that you can consider. And number one, people normally say that if they write a will, it means that they're inviting death, you know, to their doorstep. Um, I think it's because of how we are as Africans that we are not used to these things. But when it comes to the West, these things are so common and they're so normal to them. So normally people would say, mimi sitaki kuandika will kwa sababu naogopa nikiandika will, I might not even last, you know, for long. So that is one of the myths that people normally have when it comes to these topics surrounding wills. Then secondly, I will write my will when I'm about to die of old age. I did mention in the beginning that there is no time, you know, and there is no specific time when someone says, now you're 50, write the will. Now you're 70, write the will. You can write it at any age. Even minors are allowed to write wills. Of course, there's a cap to that, but anyone can write a will. You don't have to get to old age for you to write a will. And I don't own a lot, so I don't need a will. I assure you, even your personal effects, even your clothes, you know, even the things that you'd consider are so small, people might even fight for them in the event of your demise. So whatever you own, it might be little in your eyes, but you would just do a will for you to say, I want this to go to Justin, for example. I want this to go to Lillian. So that when someone is reading that will, they would know that particular item nani alisema ipelekwe ichukuliwe na Lillian, ama nani alisema nataka Justin achukue. Then my family knows my wishes, so I don't need a will. We've had very many cases where people normally fight in court because of such things, you know, when it comes to property and other things. It would be so easy for someone to go to court and to say, by the way, hiyo hakukuwa anataka. We've seen families who fight over even bodies at the time of burial because they're saying anafaa kuzikwa huku, anafaa kuzikwa huku. But now when we say that your family knows your wishes. You do not need a will. I would say that you would need a will so that your wishes are clear. If you want to be married in a certain way, for example, you want to be cremated, or you want your organs to be harvested, maybe you're in the research field and you want to make use of your organs, it is better for you to put down such things so that your family is well directed and they would do as you wish. Fourthly, my family will look after my kids if something happens to me. We know that this hardly ever happens. It happens, of course, in some families, but in many, you find that once someone dies, then the children are going to suffer. So for you to protect your children, it would be important to even have some of these things in writing. It protects them. So it is good to just have it in writing and not to assume that everyone is going to do right by your children or even your wife or any other person that survives you upon your death. Then lastly, it doesn't matter if I have a will because no one will follow it. Trust you me, when you have a will, it makes things easier. I've handled matters where some of these people, especially Indians, they do write wills. So you find the process of succession is normally very easy for them because the minute someone dies, that will is already in place. They know if there's a house, for example, if there's a property, if there's shares, if there's a bank account, they know what is going to happen. So the minute they get to court, it is easy for the court to just grant the wishes of the deceased person. Otherwise, if you compare on the other side, if someone does not do a will because they think someone will not follow it, then the law now is going to dictate on how your property is going to pass to other people. So for me, I would say that this is a myth that we have to, it's a misconception that we really have to come off, so that you are able to know that once you have a document that is valid, once you have written a will that conforms to the provisions of the law, then even your family will have no choice but to follow as you desire. So I want us to look at the importance of writing a will. I think I've mentioned some of these items as I was presenting earlier. And number one, it prevents intestate succession. I did mention that there are two types of succession: tested and intestate. So when it comes to tested succession, it means that someone has died having written a will. So the process of succession is going to sort of, it's different if you were to compare it with someone who has died without a will. In this case, when you're saying that it will prevent intestate succession, we mean that the court will not have a stake in how your property is going to be divided, among or even between the people that you leave behind. It means that the court is going to consider what you've written in that will, and they're going to do as per your wish. It means that the executors that you've chosen are going to be the ones who are going to administer your estate upon your death. It means that if, for example, you have debts, you have liabilities, and you have a bank account that you wish to go to someone else, or you want for some money to go towards payment of such debts, then that is what they're going to do. So having a will prevents some of these things so that people are able to deal with your property as you would desire and as per your directions in the will. Then secondly, it eliminates family conflicts. I think this one is it's direct, that if you have a will as a lady or as a gentleman, then it's easy for someone to know shamba ya Kileleshwa, for example, this one is going to Justin. Ile bank account, it is going to Professor Ndege, this and this and this car is going to Lillian, and such things. So it's easy for people to know that the deceased person had made this decision, so we won't do anything about it because this was his wish. Amepeana nyumba to a specific person, amepeana gari to this particular person, amepeana shares to this person, for example. So that makes it easy, and in many cases families are equally able to avoid those fights that we normally see. We have very many succession cases in court, and sometimes you go to court, you find a mother fighting the children, or vice versa, because of such things. So you would see why it is important to write a will. Thirdly, a will can be used to distribute real property, for instance, land, movable property, shares in a company, intellectual property, and personal effects. I think this one I've already mentioned. Fourthly, a will does more than name the heirs. And it is not just a matter of saying, Baroness, I've given you the land in Rongai. Professor, I've given you the car, KBW something something. A will can also be used to provide for guardians. Say, for example, you're making a provision for your children, and you're saying that once I die, I'm appointing so and so to be a guardian to my children. Some would even include in the will their funeral rights. Once I die, this is how I want to be buried, for example. This is exactly what I want. I want to be cremated. Nataka kuzikwa mahali fulani, nataka kuzikwa Lang'ata cemetery and such things. So other than naming people who are going to get your property upon your demise, it helps you to also include for such important things in the event of your death. Lastly, I will provide certainty to the surviving members of the deceased family by distributing property of the deceased according to his wishes and directions. I think this is straightforward, so that people do not start fighting for your property once you're gone. I want us to look at who can write a will. Anyone can write a will as long as they have property, or as long as they have any directions to give to the people who would survive them. Then secondly, a person who has testamentary capacity. We've already said that for one to write a will that would be considered valid in the eyes of the law, then they have to be sane, they have to be of sound mind. And lastly, they have to have attained the age of 18. Of course, there's a proviso to this item that even minors can actually write wills, but then once they attain the age of majority, then they will have to re-execute the wills. Now we are getting to the meat of our presentation and why we are here this evening. Let's look at the contents of a written will. So this would basically be the form of how a will should be. So number one, you want your will first to have the testator's name and declaration. We've already defined a testator as the person who is making the will, and the testator has to make an equivocal declaration that it is his last will and testament. This part which reads last will and testament is what is referred to as a declaration. And when you say equivocal, it means that it is a statement that has no doubt. You are sure, you are 100% sure of what you're saying. Then I want us to take note that the latest will invalidates the previous one. I would give also the example of Justin again. Say Justin has written a will. Say, for example, he wrote it in December of 2022. And then come May 2023, he decides he wants to write another will. So what the law provides is that the will that he has written in May 2023 is going to invalidate the previous one, so that there will be no two wills. Whatever takes precedence is the recent will. And then I want us to also take note that an oral will does not cancel a written will. Only a written will can cancel a written will. So an oral will does not cancel a written will, which means if you say, for example, Justin wrote a will in December 2022, and he decides in May to make an oral will. If someone was going to challenge that in court, it would be so easy, because someone would be saying he made an oral will in May 2023, but there was a written will in dated December 2022. So the will that was dated December 2022 will take precedence, and the will that was done in May, the oral will done in May 2023, will not be considered as a valid will before the courts. Secondly, in a will, you need to include gifts or bequests. So a gift or a bequest is any property disposed of in a will. We would say, for example, I want to give a property located in Kitengela, LR number this and this and this to Baroness. So that is a gift to Baroness, and you have to include it. A will has to name a gift and the recipient of the gift. Just as I've said, if it's property, for example, you need to include the LR number. You need to include the LR number of the property, and you need to name the person who is receiving that property. If it is a car, for example, you need to include the registration number of that car and the person who is going to receive that car. If it's a bank account, you need to name the bank, you need to give the bank account number where the account is held, that is the bank. And you need to say that this bank account is going to this specific person. If you have shares in Safaricom, for example, you would say that this number of shares that I hold, you mention that you have shares in this company and you'd like for them to go to this particular person. And then thirdly, this section of the will could also include any conditions to be met by the recipient of the gift. Yeah, so sometimes someone might give a gift and they put a rider to it and they say this gift will only pass to Baroness, for example, upon fulfillment of 1, 2, 3. So you could also include that in case you have conditions to be met by the person receiving the gift. So a testator can only gift away property that belongs to him. That is also very important, so that you do not gift away property that does not belong to you. If you gift away property that does not belong to you, that part of the gift, that part of the bequest, that forms part of the will, is going to be declared invalid. But that does not necessarily invalidate the whole will. That specific part where you've bequeathed someone something that does not belong to you is what is going to be rendered invalid. Otherwise, the other parts of the will are going to be considered valid before the courts of law. Then thirdly, we are looking at the name of the executor. An executor is a person to whom the execution of the last will of a deceased person is, by the testator's appointment, confided. An executor is named by the will, who takes charge of the distribution of the assets of the deceased. Remember, I did mention that once you've named your executor, then this would be the person that administers your estate upon your death. They will only just have to be confirmed by the court. And then thirdly, it is not mandatory to name an executor. And in this instance, any persons wishing to administer the estate of the deceased have to apply to court to be named as administrators. So in the event that you write a will and you do not name any executor, upon your demise, your family is going to apply to court, for them to say, person X died on this particular day. There is a will in place, but the will did not provide for an executor. Then there are going to be people petitioning the court to come on board as executors in order to administer the estate, and the court is going to look at those names that are there in that petition, and the court will decide that they be administrators of the estate. So in my own view, I feel it is better for you to include executors so that once you die, your property is in safe hands and you know who is going to administer it. Then last, number 4, we are looking at execution. So a will has to be signed by the testator or by some other person in the presence and by the direction of the testator. Allow me to mention that signing of a will is very important. A will that is not signed would even be considered a document that is invalid, because signing of a will shows that you had intention and you are actually agreeing to the contents of that document. So we are saying that it has to be signed by the testator, and if the testator cannot sign, then the testator must direct someone else to sign on their behalf, and this signing must be in the presence of the testator. The signature or mark of the testator or the signature of the person signing for him has to appear intentional. in order for it to give effect to the document as a will. This basically means that I think you've seen documents where they give space for you to sign, say for example, as a person witnessing, or as the maker of that document. If you were to sign a document and you do not sign, for example, on top of that line, someone would easily say, but this person was not intentional on signing or affixing their mark on this document, kwa sababu wamesign nje ya line, something of that sort. So when it comes to execution, someone has to ensure that sorry, the signature is intentional, so that it gives effect, and it gives strength and life to the will. Lastly, we are going to look at attestation. A will must be signed by 2 or more competent and independent witnesses. I think we've already delved so much into that. Both witnesses must see the testator sign, or the person assigned by the testator to sign, or an acknowledgement by the testator that the signature or mark by another person was made at his direction. This basically means that when the testator is signing, then both witnesses must be there. And if he is not signing, then the person who has been directed to sign must sign in the presence of those witnesses. In the event that this document was signed in the absence of the witnesses, then the testator himself has to confirm that the mark that appears in that part, by that person who signed on his behalf, was made at his direction. It was him who said, sign for me, sign on my behalf on this particular part. Then lastly, each of the witnesses must sign the will in the presence of the testator. I think I've already said that, but they need not be there at the same time. If you have 2 witnesses, you say, for example, I'm witnessing for Justin, and Dr. Ombo is also witnessing for Justin. I could sign in the absence of Dr. Wambua, but in the presence of Justin. That is what it means. Then we've looked at the contents of a will. I want us to look at provisions which are also additional. It is not mandatory for you to include these in your will, but you could add them. Number 1, you could appoint an executor or personal representative. I've already explained that, and the dangers of not appointing one in a will. Number 2, you could appoint guardians for the testator's minor children. In the event of the death, you say, if I die, for example, I want this person to be the guardian for my children. And thirdly, directions for payment of taxes and other liabilities of the testator. Maybe you have a company, that normally files returns, or you pay whatever taxes or levies to the government, or you have liabilities. Maybe you have debts that you have debts that you're paying. You took a facility that you're servicing. You could also give direction on how those are to be paid, and you could say, this is what I want to be done, this is how much is left, and this is what I want to be paid to this particular, say for example, company. I want this much to be paid to KRA, so that my taxes are paid as required, for example. It could be someone took a loan and they've not finished servicing it. Could also include it there and say, this is something that I've been paying for some time. Please, once I die, I want this amount of money to be remitted to that bank every other month. Directions on how the testator's body should be disposed. You could say, for example, I want to be cremated. I think I've already mentioned that. Or I want to be buried in this particular place, so that people are clear on how to go about in the event that you die according to your wishes. So now I want us to look at a sample will for us to see the format of how a will looks like. And then we can proceed from there. I don't know if there's any question up to that point or concern as I look for my sample will.
Yeah, question.
Maybe for me, I have a question.
Yes, please.
Yeah, what if somebody writes an unfair will? Maybe you have 3 children, but you are avoiding to allocate something to maybe the first or the last child.
Normally what would happen, someone has to go to court and challenge that will. And you know, Daktari, you've raised, that's a very lengthy, I would say lengthy topic on its own, because the law normally provides also for, what are they called? They're called beneficiaries. People who are considered beneficiaries under the law. So one would have to go to court and tell court, my father wrote a will, but I'm not happy with how that will is written. But then the onus would be upon them to also prove that they are beneficiaries. The law of succession gives provisions for who are beneficiaries, and normally the law would tell us who would be considered in the first instance as compared to other members of the family. So if someone feels that you've made an unfair representation, then it's easy for them to approach court and contest that will and say, I'm not happy with the way this property was given. In fact, I'm a beneficiary of the estate of the deceased person, and I want the court to consider this. So normally the court would make provision. There's a way they normally do it with the percentages and everything, so that each and every person who is a beneficiary not provided for properly under the will is then catered for.
Okay.
Yeah, the person might be a beneficiary. The person contesting the will might be a beneficiary, but what he or she is contesting is the distribution itself, the choice of what has been given to him or to somebody else. So my question is, what are the acceptable grounds of contesting a will?
When it comes to contestation, first you have to show, what is it called? You have to show that you have a valid reason for contesting. Basically, if you go to court and you have no valid reason for contesting, then automatically the court will not just hear you out because you've contested the will. Because at the end of the day, say for example, someone is contesting and saying that you've given Baroness the land in Kileleshwa, for example, na mimi umenipatia nini, for example, I'm trying to think, or something of a lesser value, you know.
Yes.
Land in Ushago.
Land in Ushago, you know. Someone would easily say, hii land ya Kileleshwa, it's of high value. It's of high value. I think there's some disturbance.
Sorry, Mary, please mute. Mary Karongo. Yes.
Yes, so it would be easy for someone to say, hiyo shamba Kileleshwa, in fact, it is way expensive than what I've gotten. But you see, at the end of the day, the court is not going to disturb the wishes of the deceased person because you want land that is of a higher value. I don't know if that answers your question.
Yeah, it does.
Yeah, that answers your question. So that if say, for example, I have 3 children, I've decided that the first one is going to get land in Kileleshwa. The second one is going to get a car, for example. The third one is going to get shares. Those are my wishes, and I've provided for them all under the will. You know, it's different when someone says, au wengine wamepewa na mimi sijapewa, so I'm not happy with that.
I have a question.
Yes, please.
Along those same lines,
Yes.
how about instances where the owner of the property actually intentionally wants to, what you'd call in English, disinherit? So you have, let's say you have the example of the 3 children, but the one child, maybe you've not had a good relationship for whatever reason. Maybe they have been irresponsible. Maybe
Yes.
they did not even take care of you when maybe you are unwell. But for whatever reason, but it's your property, and you have decided that I'm not giving you anything, and that's what you have documented, that there is nothing you're giving. Or is there, would that be easily contestable? Issue of the late Mutula Kilonzo, and even with the Chris Kirubi.
Yes.
We have seen, for example, the expectation was that they would leave something for an ex-wife who was formerly divorced. They did not provide, and they expressly wrote that they did not provide. But for a child who was from a different relationship, they gave what is called like a token item compared to the value for the others. Would this would Kirubi have done this in trying to prevent compensation by that child?
He would have.
Hmm.
There's someone on the phone.
Asante.
Victor, we can hear you, please. Mute.
I was
Okay,
saying
go
that.
ahead.
Yes, I was saying that he would have. Let me give, say, for example, an instance of an illegitimate child, quote unquote, because children are children, they're blessing from God. But say, for example, a child gotten not within the marriage that someone is in, for example, they hear that they're and he has left property to the other children, excluding him. It would still follow the same way that he goes to court and tells the court, look, this was my dad. He died, he has not made provision for me, but he has made provision for the other people. And in this case, you're saying that you are intentionally trying to lock out one child because maybe for some reasons you've not had a good relationship with them. They've been rebellious. Am I getting your question correctly?
Yeah, I
Hello?
think you're answering
Yes,
well.
you are. Yes, you are.
Yes, I just wanted to confirm. Yeah, so in this case, the law provides that as a parent, you provide for that child. That is what the law says, regardless. So they would easily go to court and say, in as much as my relationship with my dad was not good, I feel like he should have provided for me, just as he has provided for other children. Because the law normally anticipates that you could have many children and there would be issues between you and them. And that is always giving the instance, for example, of this other child, ako hapo nje. It is easy for them to come in and say, this is my dad and I want a share of that what is it called? The estate. And let me just mention, the issue would come in, say, for example, the mother of this child on the outside, if you've not provided for them, they would have to really prove a lot of things for them to even be included in the will. But of first instance is the child, because Article 53 of the Constitution of Kenya says that the rights of the child are paramount. They are so cardinal, so that in any case, ni yeye tu ndo atangaliwa. So they could easily go to court and say, my dad has not provided for me, we've not had a very good relationship with one another. I feel like he should have provided for me. And the court would likely take that into consideration, your feelings notwithstanding. I don't know if that answers your question.
Okay, may I ask? May I ask?
Yes, please.
Yes, I want to ask. What? How would? How is? How is it proved that a person wrote a will when he or she was of lucid moment?
Say, for example, there are some people who are known to have mental issues and they would have episodes. I'm assuming you're asking about lucid intervals.
Yes, how
Yes.
and that moment comes and goes, and it might not be present when the case is, and it might have been a long time after the will was made. How do you prove that at the time of writing the will, the person was of lucid movement?
Yeah, if they're able to understand what they're doing, and I'd say this, for example, they know all their properties. They know, for example, where the properties are located, the nitty-gritties of those properties and who they want to give those properties to, then that would be considered, because the court is going to look at it as if they understand what they have, and they understand that they're intending to give this property to someone else. So when it comes to lucid intervals, as you say, there's actually a thin line so that you wouldn't know saizi akili iko sawa ama akili bado haiko vizuri, but they're making the will. But then what would show and actually prove that they really intended to make that will are the contents of the will, and them knowing what they're willing to whichever people they have in mind.
Yeah,
So
because the
when
person coming to contest will be saying that he or she was not of good mind or sound mind. So it's the contester's word against the tester.
Yes, it is.
So that's why I'm saying, so what would be the grounds of, you can't go back to that moment and say, okay, this particular time he was of sound mind.
And you can't, because even at that time, it's too late because he has already died.
You see?
Yeah.
So I'm thinking that is not a valid. But I want to go back to, if you don't mind, to the what did you call them? I mean the what did you call the first ones? I'm forgetting the word. Yeah? That's why I wrote my will earlier, because of memory. The fact that a person wrote a will, can the beneficiaries, for example, I've already written the will, a will, can the beneficiaries distribute what I have already given them while I'm still alive? And I also want to say that the myth, is the myth I was forgetting, by Africans, that writing a will today implies that, or is taken to be an indication that I'm going to die, or it might lead to my early death. I think that is not respected. And why not? Because you know that there are psychological effects which will lead a person to fall sick, and the fact that you have written a will starts haunting you, and you could very easily die soon after that. So it's a condition that I think should be respected, and not a myth. It happens.
Yeah, because someone might actually be so sick, and I really don't know how these things work, but I understand what you're saying.
Yeah.
I understand what you're saying.
We revise the laws of succession. That should be recognized. I mean, it's not a myth, it's a reality.
It's a reality, yeah. Thank you so much for that. And just to answer your question, if you write a will and you have beneficiaries under that will, they cannot proceed to divide the property until you die. Your will only takes effect upon your death.
Oh, okay. What if I've distributed it already? What if I have already distributed the property to my children, and they can do what they want with it even when I'm still alive?
I think if you've already given it to them, then they can do whatever. Yeah, they can do whatever they want. Because normally, in a will you say that once I die, this and this should happen. But if you've already given them the authority, then I think it's okay. But then say, for example, you write a will, you have beneficiaries, then they start dealing with that property even before you die, then that will be wrong.
Mm.
Yeah.
So the best thing is to distribute the property so that there is no one will contest it. That's one. And they can do and they can do what they want with it when they are still alive. When property passes after I have died at 80 or 90, what use is it to the beneficiaries? They are already also owed.
Exactly the point. They could actually make use of it even before you die.
Yeah, so I'm laying grounds for when we next review these laws, because they are archaic. Some of them were made by Western influences, and
Yes.
yeah, they should take into account our circumstances.
And the fact that we are also different.
Yeah.
Yeah.
I also have a question.
Yes, Daktari.
This is Mary Karongo, not Daktari.
Oh, I thought it was Dr. Wambua. Yes.
Yes, and also to say something about what Justin has just said about distributing the property when you are still alive. Or sometimes why people hold on the properties is because if, for example, I'm distributing the properties, I distribute the properties when I'm alive, and I, for example, give the house where I'm living. I say this one belongs to so and so, or maybe the rental houses which have been helping me. I have seen some children taking over everything, picking out the parent who had rental houses, and leaving this person desolate with no food, no clothing. I actually witnessed about three elderly people from our place. They had distributed everything, but their children, who are not poor, the children were not poor, but they refused to help their parents. So I think that fear is what makes people hold on to the properties, even when they feel that it is felt that they should distribute. People want to hold those properties as an insurance. If I keep this shaba, when I'm 70, when I'm 90, they will help me because they want to gain favor, so that when I die, they can. So that is one of the reasons why people hold on to the properties, because of fear that they'll be mistreated and they'll be left with less and that kind of
nothing. Yeah.
Yes, but my question now, there are situations we have seen where some families go behind other people's back. When the person dies without a will, you find a few family members going out. Out there in the village, not many people do the succession process.
Yes,
so some people do not know that it is there. We've seen cases where a few people go behind some family members. They go do the succession process. They write to the administrators. They do the succession process, and they distribute the properties without some family members knowing. So in such a case, when they have distributed, if it's the land, they get the titles and change. In such a case, what happens?
In such a case, you sue. You sue them and you tell the court, these people have done fraudulent activities. This property was not even for them to begin with. They've gone against the rules of procedure, because normally when someone dies, if they die without a will, then they would have to sit as a family, go to the chief's office, so that a letter is written saying that this particular person X, died on this particular day. He was a resident of my area. I am the chief, for example, of that area. He has died, leaving behind the following beneficiaries. And that letter would actually include the full name of the beneficiary, and against the name, it would also include their ID number and the relationship they had with this person. So if it was wife, for example, if it was son or daughter and other things. So the chief would say, this is the list of the beneficiaries left behind. These are their ID numbers, and this is the relationship they had with the deceased person. So once the family has this letter, especially when they want to do now the process of administration, they get that together with a death certificate, and they apply for something called letters of administration. Now, under letters of administration, they would choose, for example, if it is the wife petitioning the court, or maybe a son or a daughter, they would say, we want to come in as administrators of the estate of our father. He died on this particular day because he was sick, and such other details. And once the court then grants that petition, then they can proceed and administer the estate. Kama alikuwa na madeni, they can pay. If there was a loan he was servicing, they can pay. If there are any liabilities that were pending, then they can pay. I do agree with you that people normally take advantage of people who do not have knowledge of how the procedure is. But in the event that such a thing happens, the family could actually go to court and tell the court, our loved one died on this particular day, and when he died on this particular day, we did not take up the procedure of administration of the estate. We did not petition the court for administration of, for letters of administration. But there were some people who, through the back door, came in and did this process fraudulently. They have done so, and so they have, say, for example, transferred property into their names and such other things. And you would list even the reference numbers of those properties, where they are located. If you know the new owners, for example, as per the title deeds, also list them there for you to show the court that indeed this was done and it was not right. Then the court would give direction based on that now. But my advice would be, if something like this happens, then you sue the people involved.
Now, I have a comment.
Yes.
Maybe take you back on the issue of the mental illness. I would say that, having a medical background, my thought would be that, yes, it becomes very easy to contest such a will because, the person just needs to produce maybe even letters and evidence of maybe admission to hospital that this person indeed had a medical, had a mental illness. However, if I would think that the people who then declare that this person is mentally ill are usually medical people. So I think the most practical way to deal with that, to document a lucid moment and to make such a will a bit more incontestable, would be if a medical a specialist, let's say a psychiatrist, is also present or is enjoined as a witness, that indeed during that period this was a lucid moment.
Yes.
Or such a patient gets a letter from their doctor saying that at present they're actually having a lucid moment, or the condition is in remission. And I don't think that would be contestable if it's done properly.
I think that would actually cure what the question was. How would someone be able to tell that at this particular point when they were writing that will, they were within that period we call in their lucid moment? So thank you so much, Daktari, for that, because then that cures that issue of lucidity. Because if, for example, a practitioner was to come and witness, then it is so easy for them to even tell court, as a witness, I was there, and at this particular time, he was lucid.
Yeah.
Yeah, so that also helps. I think we can, sorry?
Do we still have time? We can ask one more.
You can just ask one more so that I continue with the presentation, yes?
Yes, a quick list, perhaps, of a quick. Are there some grounds on which a will can be contested successfully? Can you
I
give a
will
quick?
actually go to that. Yes, I will go to that.
Okay.
Let me just, yes, let me
Okay.
present on this, and
All
then we
right.
can, yeah. So we have looked at the contents of the will. Now I want us to look at a sample will so that we know the formatting and everything, just as a guidance. I hope you can all see my screen.
Yes.
Yes.
I
So at
can.
the top, yes, thank you. At the top, you say last will and testament, and that is the declaration we were talking about, so that you declare that this is my last will. So I will have the name, the postal address, basically the details, and you would say that you revoke all former wills, codicils, and testamentary dispositions made by me, and hereby make, publish, and declare this to be my last will and testament. You see this part where they're saying you revoke all former wills. Remember, I say that a written will can only be revoked by a written will. That also goes to say that an oral will can only be revoked, or rather can be revoked by a written will. So that's why you need to say that all former wills, in case you had made an oral will before, in case you had done a written will, you are actually saying that whatever I'm writing right now is going to take precedence. I'd already done other wills before, but what I'm doing now is the current one, and I want you to consider this one now. And then you have declarations of the intention that you have. If you're married, for example, you can also include that in the will. And then you list your beneficiaries as well. I can see from this sample, they've actually put down the name of the child. So you could also have that. You could also have their ID number, just to show who they are, for example. And that also speaks to the fact that maybe they are minors or they are past the age of majority. And then you go now to the property. I want us to look at number 2 now. So number 2, I think number 2 talks about property. They're saying that I direct that all my legal shares in the above property and constituting a third of the value of the property to be shared between those beneficiaries. You could also give a ratio in terms of percentages in how you want the value of the property or the value of the shareholding in the property to be distributed between or amongst your beneficiaries. And then it says, talking about the values of the shares. Number 3, that's a bank account. That's what I was talking about. If you have a bank account, say for example, with this one is I&M, bank saving account number, that you also include the branch, and you say that you want to share, for example, the amount in that bank account with your children, and you also name them. You name them so that we say, you remember we say that if you're giving a gift to someone, you must mention the gift and the recipient of that gift. So that's why you see that they've included the name of the bank and the account number and the branch, and they're also saying they've also mentioned the names of those who are going to be beneficiaries of that particular account. And then this one, I also see there's jewelry at number 4. So I direct that all my jewelry as shall be available as at the time of my demise be shared equally among my 3 sons. You also mention their names. And then funds and loans given to my son. So I direct that all the money funds given to my son, either by my late husband or myself, shall be considered non-refundable or shall be written off. So these are directions on how, for example, you'd want to deal with people who owe you money. Number 6, In this will, you can see they're appointing executors. I appoint jointly and separately the following named person as executrix of this my will and my estate. So as you're appointing executors, be sure to put down their full name as they would appear in their national identity cards. Put down their postal addresses and their area codes. Put down also their national identity card numbers and their telephone numbers. That information must be included. Look at 6.2. I want us to go to 6.2 where she says, I have special trust and faith in my executrix, and therefore no bond or other security shall be required of them to secure the faithful performance of their duties. If any of my executrix predeceases me or fails to qualify as an executrix, or having qualified fails to act or inordinately delays to act or should die, resign or become incapacitated, then the willing and remaining executrix will proceed to discharge his or her duties as if he or she was the only one appointed. I think that is self-explanatory. So that if you have executors and one of them for some reason cannot fulfill their mandate as directed under the will, then the other person would come in and continue to administer the estate as if he or she was the only one who was appointed. And then I see at number 7, they have given the powers of the.
I have a question.
Sorry? Yes, please.
I have a question on the executor.
Yes, please.
Can you pick one of the beneficiaries as the executor?
Yes.
Can you have a beneficiary as an executor?
Yes, you can have a beneficiary as an executor. And what we mentioned is a beneficiary can only be a witness if their signature is also attested to. So that is the only change, but a beneficiary can also be an executor. Can we proceed?
Yes.
Okay, then number 7, there are powers of those who are executing. Then number 8, survivorship presumption. If my children and I die simultaneously or under such circumstances that make it difficult to determine who survived whom, it shall be conclusively presumed for all purposes of this will that my children survived me. I think that is self-explanatory. So that if, say, for example, this person was to be involved in an accident with their family and the children are also there, and people are trying to determine who died before who, then they're actually saying that they would want for it to be construed as if the children died afterwards. If any beneficiary under this will other than my children fails to survive me by 30 days, it shall be conclusively presumed for all purposes of this will that such beneficiary did not survive me. I think that is clear. And then this is what I was talking about, the burial rights. This person who wrote this will is of the Hindu faith. I think they made it clear that they would want that the funeral ceremony be conducted in accordance to their faith and traditions. So you could also provide for that in the will so that it is clear. If you want cremation, for example, if you would want, for example, for your organs to be harvested for research purposes or for use in labs, you could also do that. If you want your organs to be harvested for whatever reason, you would actually be able to direct however you want even your body to be dealt with in your will. So I think clause number 10 is normally just a general clause. It's a standard clause in a will. And then the part now for signing, for witness, for executing actually. So I dash dash the testator has set out my hand to this my last will and testament, consisting of 5 typewritten pages, this, and then you do the date. You remember I mentioned that a will must be dated, because if you don't date it, it is easy for someone to contest and say, we do not know when this will was written. It is easy for someone to come up with stories if it is not dated. And then now they sign, and then their witnesses also sign. I think this last part, let me see, let's just go back a bit. Signed by Mrs. XX is the testator. And then in our joint presence, that is the part for the witnesses. Remember, we said that a will must be signed by the testator, and the signature of the testator must be witnesses by two competent and independent witnesses. So in our joint presence, that is now the provision for the witnesses, and then by us in her presence. So now this is the part where the witnesses now are signing, but in the presence of the testator herself. So the foregoing instrument was signed and published and declared by Mrs. The testator as and for her last will and testament in the presence of us, and we, at her request and in her presence, and in the presence of each other, have hereunto subscribed our names as witnesses on the date and year above written. I think these are details now for the witnesses now. Number 1 and number 2, can see they include even the place of residence. They include even the house number and the road and the area of residence. They also include the identity card numbers. Yeah, and that would be it. This is the general format of a will. There's so many things you could actually add, just to be clear on how we want people to deal with your property, or how we want people to divide property once you die. I don't know if there are any questions concerning this document before we proceed.
I have one.
Yes, please.
The a will which is written without going to the advocate's house, or without having an advocate, is it valid?
It is valid. You could actually do it yourself. You could write a will yourself. But it is important that we include some of these things, because I imagine even before someone will tell you that you need to include, for example, let's look at provision number 2 in the will. I don't know if you can now see, I'm at page 2 now. Provision number 2, land reference number, for example. If, say, for example, you have 3 beneficiaries, you want them to benefit out of a particular parcel of land, and you have not included, say, for example, the percentages of ownership in that particular land, it would actually cause a struggle if you just leave it open. I am trying to tell you that you could actually write your will yourself wherever you are. Your witnesses can attest, but be sure to include even the nitty-gritty, so that whichever way you choose for people to benefit from your property, then it is clear in the will, so that there is no room for doubt, there is no room for questions. Someone knows, me, I'm owning this property 20%. Baroness is owning the other 30%. Justin is owning the other 50%, so that it is clear. But yes, you can write, you don't have to go to an advocate. An advocate would basically maybe help you to put some of these things into perspective, so that you are clear and direct in the will. But you can write it yourself.
Thank you.
Yes.
I have a question.
Yes, please.
Especially relating to lands. I've seen families where the patriarch of the family dies and had, let's say, a big portion of land, and also some of the sons had settled on the land, basically had built shelters, and also had started their families in consent. However, when now it comes to subdivision, you find a lot of difficulties because there are those who will say there is no way, and these are very practical things. I'll not move my property. Piece of land. There's no room for consolidation. So now back to this part you're talking of nitty-gritties. Or sometimes you find children fighting over, yes, we've agreed we are sharing equally, but who is taking this side maybe next to a road, this side next to a stream, and so on. So when it comes to these nitty-gritties, would you encourage us to actually like sketch so that you are very clear that you have placed you on this corner, you have placed you on this corner? Because those are the things we are seeing siblings fighting over.
Yeah.
In principle, they are agreed on the ratios or the percentages. But in terms of now, where you find now, sometimes even the surveyor will come and they are fighting because you will agree. It's very difficult to agree. Sometimes one person is saying, no, mine must touch that stream or must touch this side of, of something. So natural. So it becomes very difficult. So would you encourage people to sketch? Because the testator may be very clear and people normally tend to accept what the testator says, especially we Africans, because, they'll say those were the wishes of Mzee and he knew what, yeah.
Thank you for your question. That's a very good question. It would be safe to sketch. Like there's a matter we're dealing with right now. People are fighting because of an access road. So I understand what you're saying. And when the testator is able to actually sketch and says, wewe nimekuweka pale kwa kona, the other person next to the road, the other one next to the stream, mwingine katikati. It's easy so that there will be no fights afterwards because anyway, the sketch has been given, this part is mine and this other part is mine. So I would encourage that if you can, please do. So that there are some people who are greedy in families and agree with you that even the ratios and percentages might not even help, especially if someone would want now, nimepewa 75%, but the question is where? Where does my 75% start and where does it end? So I think it is good for a testator or any person making a will to be able to put that into perspective for clarity purposes.
Can we ask more questions or?
Relating to this template?
Okay. Oh, okay, we are still on the template.
Yes, if not, then I can proceed so that I finish and then we have a session for Q&A because I have a provision for that, but I want to finish first.
Okay.
Yeah. Okay, so just hold on to your question so that we finish the presentation. Yeah, so after we've looked at a sample will and how a template would ordinarily look like, I want us to look at nullification of a will. A will may be void if the testator while writing the will was influenced by fraud, coercion, or mistake. That speaks to the question that came about earlier. So these are the three instances in which a will may be nullified: if it was done through any fraudulent activity, or if someone was coerced. Someone might come and they tell you, that, by the way, you know, this and this will happen and such other things, give me this land and such other things, make me a beneficiary. And I've seen instances where people become beneficiaries within a will, yet they did not even have any connection with the testator themselves. So the courts will normally look at these three reasons. Of course, the person contesting will have to prove that that will was made and the testator was influenced for any of these three reasons before making a decision. So the onus is upon the person contesting, so that they have proof of how this was made fraudulently. And if the court indeed finds that there was any fraud involved in the making of that will, then automatically that will is going to be nullified. Let's talk about revocation or alteration of a will. A will may be revoked or altered at any time by the maker, and that is the testator basically. Just as any person has a right to write a will, they also have a right to revoke it at any particular time. The number two, a testator cannot revoke a written will through the use of an oral one. I think I'd already mentioned that. So that once, for example, Justin wrote a will in December of 2022, he can only revoke that will by writing another will. He cannot come up and make an oral will saying that now the oral will I've made is taking precedence over the written one. For you to revoke a written will, then you must prepare a written will as well. A revocation or alteration can only be done through preparing another will or a codicil. I did also mention that using the example of Justin, he made a will in December 2022. He makes another one in May 2023. The will that is made in May 2023 will be considered as having revoked or altered the prior will of December 2022. Then marriage of the testator automatically revokes any will or codicil made prior to the marriage. So this basically means like someone is yet to get married and they make a will. Definitely, once they get married, the will that they would have made then automatically becomes revoked. And this is normally because if someone is getting married, then it means, say, for example, a man, he has written a will, he's getting married in, say, for example, May. The addition to the family is this lady, which means this lady is going to become a beneficiary. And to add to it, if they were to get children, for example, then that means that there have to be provision for these people who are also considered beneficiaries under the Law of Succession Act. Then there's only one exception to that rule, that where the will is expressed to be made in contemplation of marriage with a specific person. So person X wants to get married, and they do write in the will that they want to get married to a specific person. Once they get married, then that will that they had written prior to their marriage will not be revoked once they have gotten married. I don't know if that is clear.
Yeah.
Yes, thank you. So what's next after you've written a will? You've put everything there, you've put your wishes there, how you want your burial rights to be done, how you want your body to be disposed of, your witnesses have signed as required under the law. What should happen next? So I think I already answered this question. A will can only take effect upon the death of a testator. So that if a property was to be gifted to someone, that person can only operate, or rather, how do I say this? They can only, say, for example, if it is money in an account, they can only access that money upon the death of the testator. Then secondly, there's no mandatory requirement to register a will. Once you've written a will, you could actually keep it wherever you want, There's no rule you're supposed to keep it somewhere and other things, but you need to keep it in a way that it is safe. Because even fires happen and property is destroyed. floods happen and documents are destroyed. So you have to put into perspective such natural acts of God, so that even as you're keeping the will, then you know it is safe. Then thirdly, the testator can store the will themselves, or the advocate can store it on their behalf. Yeah, if you have an advocate who assisted you in drawing the will, then they can also help you to store the will. Of course, I think there are people who charge, actually you should charge for storage fees of the will if you're storing them with your advocate, but you can keep them in your house. And I think it is important to mention at this point in time that even as you keep them, it is important for the executor to know that there is a will in place. Because if you are to hide a will and you die and no one knows that there's a will, then definitely your property is going to be dealt with as if you died having not left a will. So as you do a will, make sure that executor knows where that will is. In fact, you could even give them a copy of the will to keep, and then you retain the original. So therefore, in conclusion, preparation of a will is part of estate planning, and without a doubt, there are benefits of preparing a will, just as you've noted earlier. It is never too late or too early to write a will, because death is inevitable and no one can ever be fully prepared for it. It is not a matter of if, it is only a matter of when. And no one knows the time, no one knows the hour. We could be talking here this particular time and something happens the next minute and we are not there. That is how unsure life is, that is how unsure life is. But whichever age you are, whichever stage you are in life, I am here to tell you today that it is never too late to write a will. And lastly, writing a will is a step towards ensuring that your property and affairs are taken care of upon death, and that those surviving you are well catered for as per your wishes and desires. Yes, so I encourage us to take that step so that even our families know exactly how to go about our wishes. We tell them we want this, and by God's grace, we pray that they do as we desire, according to what we've written in the will. Yes, thank you so much. I think I'll take questions. Hello?
Yeah.
There is silence, so I don't know whether I can ask. I have asked quite a few. Am I blocking anyone's opportunity?
I think you can proceed.
Yeah. So, do I have to justify in the will the basis of the distribution? Why did I give this to so and not to another? Do I have to justify in the will?
No, you don't.
I don't.
You don't.
And the other one is there a requirement for both spouse to sign or to agree to a will, though the property right is only in one of them?
What would normally happen, you can do a joint will with your spouse, and then there could be some properties that were acquired jointly and others individually, but that will not stop them from signing. What would happen is, once you've listed, for example, the LR number of a certain property or the title number, and you've listed the location and the person who is to receive that property, then what will happen if you die? Once they've gone to court and the executors have been confirmed that they should administer your estate, the title will be provided. It will show that it is your name in that title, and it will only move that way. The process will be done so that now the name comes to the recipient's name. It wouldn't matter whether there are some properties listed in the will that belong to your wife, or there are some that belong to you alone. or there are some that you people acquired together, but you could actually do a joint will and you just list everything there in the will.
Yeah, the point is that in many cases, property is in the names of the husband.
Yes.
In very many cases, but actually, in practice, the property belongs to it's a family property. And that's why I'm asking whether there is yet a requirement that a will should be signed by both spouses. Maybe there's no provision at the moment.
No, what normally happens, you notice like in our sample will, it was only one person making that will. So they're the ones who are going to sign as testator. That's why I mentioned that you would actually do a joint will where you say I XXX and XXX. You get? So that
Yeah, but it's
it
not a
makes
requirement.
No, it is not a requirement. It is not a requirement. In fact, your wife could have their own will and you also have your own will.
Of the same property?
No, not of the same property. Say there's some properties that she has, she acquired individually, and there are some that you acquired individually. She can have her own will.
Okay.
Yes, yes. But there's no requirement. There's no requirement for spouses to sign a will together.
Thank you. Any more question? I can see Dr. Mbua is silent. Seems like he's not with us. Dr. Mbua? Yes, any other question?
Bank account that is shared, that would be covered under a joint will.
Yes.
So that you say that, say for example, the bank account held at I&M Bank, branch, blah, 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 account number this. And normally, if you were to pull out the details of that bank account, it will show your name and your spouse's name. So
Yes.
a joint will.
I think my point was a bit different. Is that even though land, for example, is only in my name, the interest in that land is family interest, and the spouse has every right to contribute towards where who benefits from that land. And if the husband does it alone, that is setting up that property for contest because of the wife's interest, which is not expressly, it's not expressed in the land, but it is assumed. That is contested, it, denies would-be beneficiaries its use for an indefinite period of time. So in that case, is it advisable in your view to discuss the will while both of you are still alive?
I think it would be important.
That question is it has many branches.
It's actually, no, I was actually pausing so that I explain.
Okay.
I think it would be important to sit down the family members, because just as you say, when you buy land, people contribute to it in many ways as a family. They might not be, their names might not be on the certificate of title, but they have contributed to a large extent, so that even as your name appears on that title, it denotes that the whole family is represented. And I agree with you that in some instances, it would be easy for someone to say, you have locked me out because my name does not appear on that title deed. So just as I said earlier, one, the issue of the joint will would actually cure this. In as much as the title deed only has your name on it, that would only be dealt with at the process of transfer. And no one is contesting that this is family property. So yes, that is one of the reasons as to why even a joint will would actually cure that issue. Number two, it would be good even for you to sit as family members, talk about these issues. Instead of drawing a will, you hide it somewhere. It's only the executors who know that there is a will that is existing. I feel like it is good for people to sit down as families and understand there is this land. In as much as it's only my name appearing on this title, this land belongs to all of us. Yeah. So I think some of these things are important. So that a will is not something that is basically done in secrecy, but every other person in the family would know, by the way, there is a will in place, there is this land, and we have such an interest also in this land, even in the fact that it is only dad's name that appears on the title deed for this land.
Okay, do we have any other question?
I have another one on related on that issue of joint ownership. There are instances where you have, let's say, as part of a succession process, maybe two siblings have been given a property, let's say a piece of land in a certain ratio, maybe 50-50. So, so formally, as part of the succession process, that land belongs to the two. Would you say that unless they get to the level where the land is actually then split, demarcated, split, and titled now into each individual's name, would you say, like, if one of them passed on while the other one is still alive, that, you know, that thing of like, if an item, let's say a car, is in the name of two people, at death, does it go automatically to become the property of the other person on that? Because that becomes a gray area. Or does the testator, can the testator include that his half or her half into their will? Because remember that we are still trying to adhere to the principle of you only will what you own. But here is a situation where, let's say, for example, let me say let's say a big property, like a truck that's worth maybe 5 million. So this truck is in the name of a husband and wife. Does this husband have a right to will his half of it into a son, as opposed to it automatically becoming now the property of the wife? I'm looking at those scenarios. I know that sounds a bit dramatic, but I'm trying to use it to highlight that dilemma, because it could be like you ended up with a sibling, a brother and a sister, as part of succession, maybe of your dad's property. There is something you own together. And now one of these parties is doing their will for, among others, that property, because I mean they have an interest, so they have some ownership, but it hasn't gotten to the level where now there is title iko kwa jina yake, so that now he's putting it as LR number this, but you still would need to mention that ownership, even if that process has never been finalized.
I think you would have to mention. Thank you, because you're asking the question and also answering. You would have to mention, say for example, the example of the truck, and you say they own it at 50-50, right?
Yes.
And then person X wants to write their will, and they would want, are these people married? Or are they just business partners?
Married.
They're married.
So I'm looking at a scenario. I'm actually looking at the more accurate scenario is actually a scenario where they are siblings. So maybe they inherited it from their dad.
Oh, so they're siblings.
Yes. But now one of those siblings is is doing a will, let's say after, this kind of outreach, is saying, okay, I have many properties all over, let me write my will. So that property then, how do they best capture it in the will?
Normally there are, just as you said, joint tenancy is normally 50-50. And there are rules so that if one of the owners dies, then the property automatically goes to the remaining, the surviving partner, for example, for lack of a better word.
Yes.
In this case, you said these are siblings and they inherited from their father.
Yes.
One of them is writing their will, and we want to know how they're going to deal with their share of that track, right?
Yes.
In my own view and in my honest opinion, from a legal perspective, they could actually will it to anyone, whoever they want.
Okay.
Yes, they would actually will it to anyone, whoever they want. In the event that, say for example, this was a joint tenancy, say for example, a husband and a wife, and they own 50-50, and it is clear even on paper that this is a joint tenancy, then if they were to will, they would actually have to do a joint will.
Yes.
And do it just as you were saying, as if they were willing to people as a couple, not independently.
Okay.
Because the interest that they have in that property is shared in half. And if one of them was to die at any particular point, then the other remaining, the surviving person would automatically get the other share of the person who has died. So in the event that it is husband and wife, then a joint will do. If it is just siblings, then from my point of view as a practitioner, then they can do their own will and give the property to anyone as they desire. Their share in the property, that is, as they desire.
Okay.
Yes.
All right. Thank you.
Okay, thank you. Is there another question? I can see time has really gone, but I think the meeting was very useful. I hope, James, now you can be able to write a will if you had not written.
I'm definitely going to do it. I've wanted to write one for the last 3 years. So it's on a to-do list, and that's actually what caught my attention when you sent the initial email a few weeks back.
Okay.
And I said, I mean, it's something I've been saying I want to do. Let me listen. And
yeah.
and it moves it from, you Google, you read around, you see even the sample wills, but going through this session and the clarifications is, gives it a different dimension. So now you are quite clear how to go about it.
Okay.
One, Dr. Can you allow one more or so? And we have adopted children, some of us. Are they entitled to, how shall I ask this, to the distribution of our property? Or do they have a claim?
How long have you...
Let me, it's not me personally. I know what I will do with my adoptees, but do they have a claim? Are you saying that then it depends on how long they have been adoptees? And the other one which you proceed with at the same time is whether a dispute on wills is one of those that can be mediated. Is it one of those that the courts encouraged for mediation rather than through a judicial process?
Okay, so number one, adopted children would basically be considered children under the provisions of the Law of Succession Act. They are considered as beneficiaries. So number one, yes, they are entitled. They're entitled to your part of the property, whichever share you're going to give them, but they are entitled to, because you've been taking care of them as though they are your children. Then secondly, whether such disputes when it comes to wills, whether they are normally referred to mediation. Normally, I have seen where people have, I've not seen a specific one where a will is contested and it is referred to mediation, but I have seen issues to do with intestacy, where there was no will and families were fighting, say for example, children fighting the mother for whatever reason because of property, and the court would not be so quick to making orders, because at the end of the day, you know, when it comes to succession and family issues, you want to try as much as possible to maintain relations in the family. So an order may be maybe for the benefit of one party, but it may affect another party adversely. I have not seen specifically where in the event that a will is contested, it is referred to mediation, because say for example, someone comes and says, you know, you've not provided for me in that will and I am your child. For me, if I'm sitting at the seat of the judge, for example, that would be easy, because one, I'm going to ask how you related to the testator. That is one. How can you prove, if you're saying they are your father or mother, how can you prove that they are your parent? I go back to Article 53 of the Constitution. I look at your rights, for example, as a child, if you are a child, that is. I go to the Law of Succession Act, which provides for beneficiaries. Given the, say for example, even a DNA, even if it was carried out, and you have proven that this person has been taking care of you, do you fit the provisions of who a beneficiary is? And for me as a judge, I wouldn't refer such a matter to mediation, because it is about facts. Yes, it is about facts. If you're saying that you're a child, even if I take you to mediation, it will not help. What we need to know, you are claiming you're a child, go do a DNA test. I make that order, I send you, go do a DNA test. Come back with the results so that you can proceed. So I've not seen such a case for the time that I've practiced in the family division. But if it was me sitting in that seat of a judge, I wouldn't refer such a matter to mediation.
No, I was asking about wills generally, not about the adoptees, but whether disputed wills are referred to mediators generally, not about not necessarily with the reference to adoptees.
I've not seen, but I was just explaining from my point of view as a practitioner, and if I was sitting at the seat of a judge, and I had such a matter before me where someone is contesting a will, personally, I wouldn't refer it to mediation, because you know it's about facts. Yes, I wouldn't personally, I wouldn't refer it to mediation. And two, I've not seen such an instance for the time that I've practiced in the family courts. Yes.
Okay, thank you.
On the same issue, I've seen provisions where someone writes in a will that because they're anticipating that there is a party that is going to contest, where they say that whoever contests then will not inherit anything from them. Are those such provisions legal or ni vitisho tu?
Hiyo ni vitisho tu, hiyo ni maji moto, haichomi nyumba. Ni maji moto yenye haichomi nyumba. You can't do that in a will.
And then closely related to the adoptee issue, and I know we are really running out of time, we're really stretching it. Now, there is this issue of dependence in the context of, let's say as an uncle, there is a niece or a nephew I support. So is this child I educate and so on. From a very practical perspective, because these are, you know, sometimes when you're doing your will, you're thinking of your kids, obviously, or your wife, your kids, and all that. So you might leave this out. And I've had, you know, like sometimes that can bring problems because they can be used to undermine the will. So what from a very practical perspective, would it be wise if, let's say, by the time you're writing a will, there is such a child, then you make some provision for continuation of that specific benefit, maybe for exam or whatever, for school fees, so that then it doesn't come out that I was going through secondary, I'm now in Form 2, and I've had to drop out because my uncle has died. And that's why I'm contesting the will.
It would be important, thanks for that question. It would be important to provide for them to avoid such situations. Remember, if you've been carrying out such responsibilities all along, technically they would be considered your dependent. So it would be easy for you to provide for them in the will. Say, I've been paying school fees for X and X and X and X, and even upon my death, I want that to continue so that they never miss out on school. It will save you, because if this person was to go to court today, it is so easy for them to show that by then my uncle has been paying my school fees since I was in class 2 or whichever class I was on. And the court is able to see that continuity. And I assure you, they'll be able to say this person is a dependent, and they needed to have been provided for in the will by the testator. So for you to avoid all that hassle and even the inconvenience that comes even to other family members, I would advise that you also provide for such people who are also needy, and that you support even in the family who are not your immediate family.